Record. Good morning. This is Kathy Beatty with Divorce Support Anonymous, wanting to bring you information to help you go through this journey of divorce. Very fortunate today that I'm going to interview one of our local attorneys who I respect her opinion, her thoughts, and I also know that she has the knowledge to bring to us in answering some questions that have been posed to me that are legal and a little complex, and she's going to give us some information on that. So let me introduce you to attorney Amy Rademaker. She has practiced law in Western Michigan for over 27 years. She practices law in 7 different counties. Her practice is in litigation in the courts and participating in mediation. She is an appointed Kent County Family Law Court referee for juvenile delinquent arraignments and CPS orders. She teaches the legal portion of concealed pistol license permits, a multi-practice attorney who must be so incredibly busy, and I am thrilled that I could schedule any time with her at all. So please help me welcome Amy Rademaker. Good morning, Amy, and thank you for joining us today.
Yes, good morning. Thank you.
I am looking forward to your answers on these questions because I know that they are questions that many people struggle with. I also know that we are talking about Michigan law here, so we want to do that disclaimer because it varies from state to state and even county to county. Would you speak to that, Amy?
Sure. So it is true, each law has their own legislation which dictates discovery, custody, support, particulars in their state, and divorce in general. But there is such a thing called the Uniform Child Custody Act and child support. It's called a Uniform Reciprocal Act that is state to state adopted. So there is some consistency between the states with those two issues, but every jurisdiction, even counties, have their own particulars. So a way that I might do a motion in Kent County might be very different in the procedure and the way I would set it up in a different county. And for that matter, even depending on the judge you might draw. So there's all sorts of nuances that take place in the decision as we're moving forward in a case.
How do you keep them all straight when you're dealing with in all the counties that you service? That has to be mind-boggling to keep all those dynamics straight.
You definitely have to think first. It comes, with time, of course. You get to know your judges and your courts, which is why a lot of times if I get calls from people way out of the jurisdictions I work in or out of state, even I get calls out of state they may have moved, but their case is still in Michigan. Depending on where it is, I'll refer them to more local counsel because I do feel that you need to know the ropes, the inside scoop on procedure and judges and clerks and referees. And I think that just gives you a better quality representation.
I appreciate that very much. Yeah, there is so much to know, and that's why it's so important that we do have the experts to refer to. So I've been faced with these questions, and of course, I'm not an attorney, so I'm not going to respond to them, but I thought these would be great for a conversation with you. And realizing again that it's going to differ where you're at, so you would need to consult with your own attorney on these questions, but this can help give you a general idea. Is that safe to say, Amy?
Sure.
Okay, great. So first question. My wife won't return any information for the discovery. She's unwilling to cooperate. It's taking over a year, and we have been waiting on her excuses. What options do I have to get this divorce moving along?
Okay. So when you start out a case, you do have an option of just requesting general information from the opposing side, such as bank account information and retirement accounts and things of that nature. And oftentimes attorneys will cooperate voluntarily because that keeps the case costs down. But there are certainly times when you're not getting prompt responses or delays. And so what we do is we utilize formal discovery. And what that means is that I would send formal questions or subpoenas or request for production of documents to the other side, and that mandates that they have to respond and provide the information within 28 days approximately. If they do not, and you're generous in giving them a little bit of leeway, which we often do as a professional courtesy, then you can file a motion to compel. And that tells the court that I've given them this request for information, they're not responding, and we need to keep this case moving forward. So sometimes it's okay to give a little bit of time for people to respond, but then you have to draw the line in the sand and force it through the courts in order to keep your case moving forward. So I would suggest in a specific case, you have to know how much time your attorney has given the other side that latitude, and just really request your attorney to say, hey, let's get this into court and let's get it moving.
Because that is not typical for it to last that long. And yeah, I appreciate that. So there is something that your attorney can force the hand, if you will.
Absolutely. Yep. In fact, in Kent County, our judges are very strict on keeping a case moving forward. You can even, let's say there's a simple issue that you know, like your attorney would know, the judges, perhaps just knowing the judge what they would rule on, and we are disagreeing whether you're entitled to a certain portion of equity of the home or something. If I know our settlement conference isn't like 4 months scheduled down the road, I will call the court and ask for a quick conference to get the other side in there for us to say, let's present the issue to the judge and get a quick ruling. And it's just all informal. But then the other attorney has the ability to say to their client who might be malingering, hey, the judge just said this. This is how it's probably going to work out. Let's get this case done. So that's kind of a nice little tack to do to even give the case a push.
Yeah, great, great. Second question, the father refuses to follow the court order of parenting time. What rights do I have?
Okay, so that's a tough one because there can be many reasons why the father, in this case the father, is refusing parenting time. So you can't force someone to follow the court order in the sense of exercising their parenting time. It's kind of ironic because you can certainly show cause someone who's not granting the parenting time pursuant to the court order, but you can't make that non-custodial parent be the parent. But what happens with those is the child is emotionally torn every time they're getting ready and expecting that parent to come in, as well as the parent who's getting the child ready, maybe making plans, and then having to cancel everything at the last minute. That's very disruptive to that child. So if it happens consistently, I would file a motion to modify the parenting time, indicating that this parent is not exercising the time, it's detrimental to the child and an inconvenience for the parent. And we need to either limit it to just only one time a week or every other week. I've even gone so far with some cases that I've had where if the non-custodial parent did not contact my client 24 hours before their parenting time to confirm they're going to be there, they forfeited their time. That way, the parent has the ability to quickly go to plan B and not get the kid ready, and that way the kid kind of doesn't know the difference. I just think it's really sad for that child, that's for sure. The other thing that you can do that kind of money talks is motion to modify child support. Because if the parent's not exercising their court-ordered parenting time, child support, at least in Michigan, is dependent also on overnights. So it doesn't matter what your court order says. So you would show that for the last 52 overnights, they've only exercised 3. Their support will change. And boy, that's a motivating factor if you start talking that with the other side.
Yeah, it is heartbreaking. I know you see it and I see it of parents who are doing such harm to their children by using them as I don't know, pawns or whatever to hurt the other parent, or just they're not putting the best interest of the child in this situation. And parenting time is vitally important. Kids need that so much. So
Absolutely.
thank you for that response. And so let's go on to the next question. So my husband was self-employed and I know he has a lot of money hidden. Is there anything that I can do about it?
Okay. That question is such a potentially difficult one when, I know there's money hidden. So I would be like, okay, what do you know? Sometimes we have to hire investigators to kind of follow the paper trail. We can send subpoenas to banks in order to discover accounts, but that can end up costing so much money. And that's where this kind of ties into the first question about discovery, enforcing questions and discovery of information. You would send documents to that other side asking them to display it, and look at bank accounts. Those are very telling on where money is going from place to place. You can do depositions of maybe workers in their business. How often are you working? And if they show such a small income through their business, but they have 3 employees who are busy each 40 hours a week, every week, where is all that money and activity going? So it just doesn't make sense. So you kind of just build your case up depending on what facts you have, and then using that discovery as a tool in order to try to find the documents and follow the paper trail.
And what would be, if it was later discovered, money was discovered after the divorce was over, I'm sure that the courts would not look favorably upon that. So what might happen in that scenario?
In our judgments of divorce, I always make sure that there's a paragraph in it that indicates that the parties have fully disclosed all assets that have been acquired during the marriage. And if it's discovered that they have not, that they're subject to actual sanctions of attorney fees and costs. And the court will then make a decision on what to do with that discovered asset, and either divide it between the parties, or because of the lack of disclosure and kind of how badly they hid it or fraudulently they did, the court can sanction them and even award more than 50% to that harmed party. So there are good enforcement measures for that.
It's just so complicated. It's just not worth it to hide, is it?
No. And yeah, the courts do not look favorably. I know our judges just truly would no problem sanction that party for attorney fees. So it's not a good thing to make the judge angry, that's for sure.
Yeah, that is for sure. So the next question is very relevant to this current pandemic that we're in. My spouse and I have separated. We filed joint taxes and he refuses to give me my share of the stimulus check, the $1,250 or $1,200 for my individual payment. What can I do?
Okay. So separating to me just means that you have physically moved apart. There is an official court action called a legal separation. And for all intents and purposes, it's a change of caption. It's either legal separation or divorce, but all the same procedures take place. And there's really, without a court order, you can't necessarily force anyone to do anything. So it might cause you to file at least a legal separation and then get a court order that says he has to provide that stimulus check to you. The other thing I was thinking about is perhaps if it goes into a joint account, you could immediately request the bank to freeze it, and also report maybe to the IRS or whatever that the check came and is either in an account that you can't access or something to that effect, just as a quick measure to try to save that. But really, the best thing and most immediate thing where there's some teeth to it is to have to file a court action to get a court order.
And you do want to be careful that you're not spending beyond your 50% of that check in legal fees, right? We see that where people will spend more in legal fees and court costs than actually the item is worth.
True. I constantly remind the value of some arguments to my clients to try to shore things up, that's for sure. So in that situation, the court can certainly be informed when a case is opened that this incident occurred, and therefore I want credit on my side of the ledger when we're dividing other assets for my portion of that stimulus check. And that's often honored and enforced by the court.
Sure. Okay, so the next question is really a two-part. It's similar to the first question that I asked, but I think there's a key phrase in here that that needs to be addressed. The question is, are there legal ways to get him to speed things up or to hold him responsible for not providing the documents early on? The only problem with that is that he filed, so I'm not sure if I have a right to say anything.
Okay, so we did talk about how you force someone to respond to documents through motions to compel and discovery items and stuff like that, formal discovery. But the fact that the other party filed, it doesn't matter. You still have all the full rights and the same court rules as that first person who filed in order to enforce and get the case going. It actually happens quite a bit. What I do in those situations is, again, I contact the court and say, we would like a quick pretrial conference, or like right now, especially with this pandemic, so many of our court cases have been adjourned. So what I've been encouraging my opposing counsels to do is we schedule Zoom mediations, and it forces the case to still be brought forth, the parties to be together, the attorneys to be together, and we're still able and have been able to move some of our cases along. The party, it doesn't matter who files, you have the right to continue and push the case through the court, regardless if the other party is cooperating or not.
And that is so important to know. Thank you for sharing that. So I've been also conducting the Zoom mediations, and it is working, and it is allowing people to get some progress completed. And I think it's a wonderful way to get this over with and to be able to make that progress. So how's it going for you in using Zoom and getting all of those done?
It's gone well. In fact, it's been super convenient. I have a client who actually has now moved to Indiana, and so he was able to join us, and we're in our separate room to where we can talk, and then the mediator comes in and out. So very private. It felt very comfortable and was very successful. So I'm thrilled about that. I've had a court hearing through Zoom in Polycam, they call it, into court on a couple of criminal matters. So that has worked well too. The only thing that is an inconvenience is emergencies. I can't call up the court and ask for an emergency Zoom meeting. And in fact, just this morning I had an emergency, and I'm drafting an ex parte order to quickly get relief from the court in order to actually a parent's moving out of state and taking advantage of the lack of court hearings. So it's been helpful, the Zoom and the mediations online. And if all else fails, we do have these emergency ex partes that we can get into the court for immediate relief. But I'm trying not to use those too much because it's just, I'm sure the courts are a little overwhelmed as well with what do we do.
I bet so. But in mediation, you can get all of it complete, really, except for being filed in the court, right? So you know where you stand, which I think is wonderful for folks to at least know, because that limbo is so difficult.
For sure. But we did resolve a case in mediation 2 weeks ago. The attorneys drafted the documents. We've got them all signed, and I entered it with the court just last week. So we actually accomplished a complete resolution of a case during this time.
Right. And mine, I had some agreements as well, but I didn't know you could register them with the court right now.
Absolutely. Yes,
Wow.
the clerk's office is still, they rotate and, limited staffing, but yes, you can mail it in, and even our courier service still has delivery. So yes, you can still get consent documents entered.
Oh, that's nice to know for
Mhm.
those of you who are thinking that everything has to stop until the divorce is, or until the courts are open. It's good to know. So there's one other follow-up on the last question. I'm
Yeah.
sorry, I had a little rabbit trail there. But she states, he was the one who filed. I'm not sure that I have any right, which you responded to. But then she said, I was the one that provided the income. Does this give me any advantage on the IRA equity?
So any asset that accumulates or is acquired during your marriage is marital property, and therefore the standard is subject to a 50-50 division. The only exception to that would be, a small exception would be fault in the breakdown of the marriage relationship. Fault is still a factor that the court can consider out of many factors in the distribution ultimately of the asset, but they look at fault as being, how did it affect the like the asset? Did the asset go away like a gambler who spent all of their IRA and now mine's only left? It's not fair. That would be a good example of fault being taken into consideration, that maybe her award would be more. Um, and also whether any portion of that accumulated prior to the marriage, that premarital amount would be taken away, and then only the part that accumulates during the marriage would be split 50-50. So in general, if it accumulates during the marriage, it's split 50-50, but some of those slight exceptions can make a difference in an argument.
Okay, great. Are there any final thoughts that you may have, Amy Rademaker, about to help folks, your clients, get through this pandemic? I say we're going through a double trauma if you've got a divorce and a pandemic. So are there any other words of wisdom to help guide people through this legal process right now?
Well, obviously patience is key regardless. And, with my cases and clients, I can only really speak to how I've been trying to work through them and this situation. And obviously, in any case, always communication. And if you're frustrated with not knowing what's going on, um, you've got to be able to communicate with your attorney, and either by email, if they're kind enough to allow texting. With technology today, there's really no reason why you shouldn't be able to have some form of communication to understand what's going on. And also know that you're not the only client, and to have a little grace in having response. But certainly you should know what's happening next, and if there's something going on, being able to send an email or whatnot to your attorney and getting a response back in order to understand what to do next and things of that sort. And I just think the person-to-person contact, you shouldn't have to desire that. You can accomplish everything, frankly, over email and phone, and just maybe give a little bit more patience to a response time. But yeah, just hang in there. And when this all opens up, there's going to be such a floodgate going on at court. It will probably be yet another letdown of delay because of everybody trying to get into court. But just communication is the key always, with your comfort level and your attorney keeping you informed of what's happening next. And hopefully that will get you through this.
That's awesome. And if the courts are going to be so full when they finally do open up, that really leans itself more to getting that mediation, getting that agreement, and then having it submitted to the courts now before they open back up.
Absolutely. I am encouraging all of my cases right now into mediation for exactly that reason, because it's not going to help in the next several months to get into court any sooner. I think we can take care of mediation during this month and then follow up with paperwork and stuff and just really keep on schedule. So it's key right now. It's an awesome tool for sure.
Great. Thank you for the information today. Just to get people a little more informed, put them at ease. We're always empowered when we have knowledge, when we know a little bit of what's going on. And the legal world for many of us is confusing because we've never been here before. So thank you very much, Attorney Amy Rademaker, for responding to those questions, and I will put her information posted with this interview. So if you have need, you're local to Grand Rapids or any of the other counties surrounding, she certainly would be an asset to have on your team. So thank you very much, Amy.
Thank you so much. Enjoy your day.
Thanks, you too. And we will connect soon on Divorce Support Anonymous.